Good morning and welcome to the Supreme Court of the United Kingdom, where today we are beginning the hearing of the appeal in the case of Friends of the Earth and others and Heathrow Airport Ltd. The appeal is concerned with the proposal for a third runway at Heathrow Airport and the climate change implications of that proposal. Heathrow Airport are represented by a number of counsel led by Lord Anderson, and I'm going to hand over now. He will need to be unmuted. Well, while we're waiting for him to be unmuted, perhaps I should explain that I'm hearing this appeal along with four of my colleagues, Lord Hodge, Lady Black, Lord Sales.
Good morning.
And Lord Leggett.
Good morning.
I think we now have you unmuted, Lord Anderson.
I hope your lordships and your ladyship can hear me.
Yes, we can. Thank you.
May it please the court, I appear for the appellant, Heathrow Airport Ltd, with my learned friends, Mr. Humphreys QC and Mr. Richard Turney, both of whom appeared below, and Mr. Malcolm Birdling. The respondent, Friends of the Earth, appears by Mr. Wolfe QC, Mr. Lockley, and Mr. Parkinson, and the respondent, Plan B Earth, appears by its director, Mr. Tim Crosland. There's a great deal of material before the court about the threat of climate change, the human contribution to climate change, and the need substantially to reduce global net carbon emissions, including from aviation, in order to mitigate its effects. None of those principles is open to serious doubt. They're certainly not disputed by Heathrow Airport, inside or outside this court. Indeed, the company has a strategy for eliminating carbon on the ground, decarbonizing flight, and removing carbon from the atmosphere. It's committed to playing its full part in avoiding or mitigating the harmful effects of climate change, whether on the ground or in the air, in accordance with whatever laws may be in place at the time. At issue in this case is a far narrower question, whether the Secretary of State acted lawfully in June 2018, when after exhaustive public consultation, expert advice, and parliamentary consideration, he approved a statement of government planning policy, the airport's national policy statement, which I'll call the ANPS. The function of the ANPS, as it states itself, was a specific one: to set out government policy on the need for new airport capacity in southeast England, to identify its preferred location, which was the northwest runway at Heathrow, and to provide the framework under which any future development consent application for such a scheme would be considered. Of course, the wider background of law and policy on climate change had to be taken into account, and was taken into account in the preparation of the ANPS. The central issue in this case is whether the Secretary of State acted rationally when performing this exercise, and in particular, whether he was required to have regard to the provisions of the Paris Agreement signed in, adopted in December 2015, signed, I think, the following spring, which spells out a global long-term temperature goal and a further goal of achieving in the second half of this century, the so-called net zero, a balance between the anthropogenic emissions of greenhouse gases and their removal from the atmosphere. If the Secretary of State were here, I'm sure he would tell you that the strong leadership of the UK in this area is a matter of record. When the Climate Change Act 2008 provided for an 80% reduction in carbon emissions from pre-industrial levels by 2050, this was the most ambitious statutory target of any country in the world. And when the target was amended in 2019 to provide for a statutory 100% reduction, net zero, the United Kingdom was once again the first major economy in the world so to legislate. These are achievements for which the overused term world leading are, we submit, appropriate. But the respondents are among those for whom the evolution of national law and policy on climate change has not been fast enough to keep pace with what they describe as the climate emergency. They have acted repeatedly on this, as they're fully entitled to do, by campaigning, by responding to consultations, and by legal actions. Most relevantly, Plan B Earth brought a claim against the Secretary of State in December 2017, 6 months before the ANPS was designated, in which it submitted that the Secretary of State had unlawfully failed to revise its 80% carbon reduction target in line with the Paris Agreement, by then ratified and in force. That claim was refused permission in the High Court in a reasoned judgment of July 2018, which I don't take the court to at this stage, but which starts at 2138 of the electronic document numbering, Mr. Justice Supperstone. A renewed application to the Court of Appeal was also refused, I believe, without a reasoned judgment. In this case, the respondents once again seek the aid of the courts to advance government policy on climate change, this time by challenging an outline planning decision. And that attempt founders in our submission for essentially the reasons that the divisional court gave in this case when it refused permission on the grounds now before the court. Domestic law and policy on climate change, as they stood in June 2018, were clear whether the respondents liked them or not. It was the duty of the Secretary of State to have regard to them, but not to go beyond them. It was always possible, even likely, that law and policy would have to change as part of the UK's developing contribution to the global long-term Paris Agreement goals. But changes to law and consequently policy had not yet materialized. The Expert Commission for Climate Change had advised that such changes would be premature, and it cannot sensibly be suggested that designation of the ANPS would frustrate or render impossible the achievement of those long-term goals or the making by the UK of an appropriate contribution towards them. Nor, I would add, did the designation or wording of the ANPS prevent further developments in law and policy from being taken into account, either by a review of the ANPS, should the Secretary decide to conduct one, or when Heathrow does apply for a development consent order, which I'll call a DCO. This is not some capricious exercise of discretion by a minister, but the implementation of a long-standing policy commitment that was consistent with the expert advice of the Airports Commission and the Committee on Climate Change, that had been the subject of 2 national consultations in 2017, that had been scrutinised, debated and voted on in Parliament, and for which the Secretary of State could be held accountable to Parliament and to the public. In those circumstances, the decision is, to quote the Court of Appeal in the Packham case on HS2, which is document 3086, a macro-political one, one with which the courts should be reluctant to intervene, and the Court of Appeal in our submission was wrong to do so. What I propose to do this morning is take the court first to the applicable legislation, then to Paris and its sequels, and then after laying that groundwork, and I hope rather more speedily as a result, to our submissions on each of the 5 grounds of appeal. But before I do so, may I dispose of 3 preliminary matters that the respondents have raised in their written argument. First, may I deal very shortly with the suggestion at Plan B's case, paragraphs 82 to 83, that Heathrow, and I quote, is no longer planning for a 3rd runway, a suggestion supported by the first paragraph of Friends of the Earth's case, in which Heathrow's aspiration to add a 3rd runway is referred to in the past tense. My instructions are very clear on this. Heathrow Airport Ltd does still wish to construct the northwest runway. Even if everything went smoothly from this point on, it is a project that could not be completed before 2030 at the earliest. We must all hope that the effects of the pandemic, to which Heathrow's Chief Executive Officer, John Holland Kay, was referring in the passage cited by Plan B, will by then be a distant memory. The second preliminary point, emphasized throughout its case by Friends of the Earth, for example, at paragraphs 16 to 22 and 73, is the suggestion that this court is bound by what are described as factual findings or evaluations by the Court of Appeal, exercising, it is said, its original jurisdiction as the first instance court. That submission urges this court to show towards the judgment of the Court of Appeal a margin of appreciation more usually accorded in a case of this nature to the Secretary of State who made the decision. It is, we submit, a dangerous submission for Friends of the Earth because it relies entirely on the proposition that it was the Court of Appeal rather than the Divisional Court that was the first instance court, how they put it at paragraph 18. It's true that on the claims with which this appeal was concerned, the Divisional Court refused permission to apply for judicial review, and that the Court of Appeal then went on both to grant permission and to decide the substance. But this was not a case like Spath Holm, in which it was the Court of Appeal that had the first shot at the issues after a short hearing at which permission had been refused by a single judge. In this case, there had been a full rolled-up hearing over 7 days in the Divisional Court, with a further 3 days for the Heathrow hub claim, in which, as the Divisional Court said at paragraph 4 of its judgment, we heard full argument on all issues. The judgment of the Divisional Court, which occupied 669 paragraphs and 3 appendices, was described by the Court of Appeal, paragraph 7, as a tour de force. Lengthy passages of it were adopted by the Court of Appeal, for example, in respect of the standard of review at 126 to 143. And its treatment of what is now ground 2 in particular is far more detailed than that of the Court of Appeal, some 4 pages as against less than 1. In every respect, the judgment of the Divisional Court was treated by the Court of Appeal as a conventional first instance judgment. For example, 187 to 195 of the Court of Appeal, where the Divisional Court's reasoning is summarized at some length. And if you go to the end of the Court of Appeal's judgment, the conclusion section, you see the Court of Appeal emphasizing the long-established limits of the court's role, and then saying, as an appellate court, we operate within the same limits. So it saw that it was operating as an appellate court. The following paragraph, we are required to determine whether the Divisional Court was wrong to conclude that the ANPS was produced lawfully. So a classic appellate exercise. And then 283, to a substantial extent, we agree with the analysis and conclusions of the Divisional Court. And indeed, even Friends of the Earth sought to hold the Divisional Court to the standard associated with a full first instance judgment, as recorded, for example, at paragraph 250 of the Court of Appeal, where his appeal on what is now ground 4 was summarized as a criticism of the Divisional Court for failing sufficiently to address or give reasons for its conclusions. It's true, of course, that the Divisional Court had other arguments to deal with in those 669 paragraphs, though by my calculation, more than 200 of those paragraphs were devoted either to the arguments now before this court or to legal and factual matters highly material to them. Another point, Friends of the Earth's argument has to reckon with the fact that, as the Divisional Court recorded at the end of its judgment, 667, paragraph 667, permission to appeal was granted on a number of grounds advanced by the London boroughs, including 2 that concerned the SEA directive, which is a subject matter of our ground 3, and 1 that concerned consultation. As the Divisional Court said in that same paragraph, 667, having heard full argument on all issues, it is a somewhat curious exercise to determine which grounds were arguable and which were not. Yet on Friends of the Earth's case, that curious exercise takes on incalculable significance because it determines the issues on which the Divisional Court had original jurisdiction and those on which it did not. So the argument presented by Friends of the Earth on this, central as it is to their case, is in our submission unduly formalistic and, in the circumstances of this case, wrong. I'd like to refer the court to one authority which appears in a supplementary authorities bundle. I'm afraid I'm not sure whether it's got onto the electronic system or whether your lordships and your ladyship have been furnished with a copy of it. But it's the case of Foster, a decision from 1992, which appears in the supplementary authorities bundle at 32.
Yes, we do have that, Lord Anderson. It's in a supplementary bundle.
I'm relieved to hear it. I've got it here on paper. Chief Adjudication Officer and Foster, page 32 of the supplementary numbering, a decision of the Court of Appeal. And I really take you to it only for one short reference on page 49 of the report, that is page 50 of the electronic bundle. It appears under the heading, The Powers of the Court of Appeal. And it's a case on the, yes, so there's a paragraph about the statutory appeal provided for in that case. And then under the letter E, the court continues, this is not, however, the end of the matter. This court has a curious quasi-original jurisdiction in relation to judicial review. If an application for leave to apply for judicial review is refused by the High Court, it can be renewed to this court, and if granted, the substantive application can be heard by this court, although the usual practice is to remit it to the High Court for hearing. So that's, of course, what happened in this case, but we rely on the description of the Court of Appeal's jurisdiction as curious and quasi-original. And in our submission, it simply isn't realistic to say that the Court of Appeal approached this matter as a court of first instance. That function was very plainly done, performed by the divisional court. Indeed, to treat the Court of Appeal's judgment as first instance would be absurd. My third preliminary point that I wanted to get out of the way or to address is the question of the concession. Both respondents place weight on a concession made by the Secretary of State, well, not by Heathrow Airport Ltd, but by the Secretary of State in the course of the proceedings. And it's worth briefly addressing that point to explain, if I can, what was conceded, and secondly, the consequences of that for the case. The way this is put by the respondents, I can just give you the references to their case. It's Plan B, paragraph 81. They say that the Secretary of State acknowledged that he had disregarded the Paris Agreement as not relevant. And Friends of the Earth at 11B say that the Secretary of State accepted that the ANPS might have been different had he considered the Paris Agreement. The very last sentence of Friends of the Earth's case is to similar effect. And in our submission, neither of those is a correct characterization of the concession. There was a concession by the Secretary of State, or a helpful narrowing of the issues, as Mr. Justice Holgate also referred to it at document number 1833. It arose in the context of an application by Friends of the Earth for disclosure against the Secretary of State in a directions hearing in the divisional court, or in the High Court at any rate. The Secretary of State was then asked to plead the accurate position, which he did in amended detailed grounds in respect of both the Friends of the Earth and the Plan B claims. And I'd like to take you to the amended detailed grounds in the Friends of the Earth case, which is at page 687. Horrible feeling, your lordships and your ladyship are finding this more quickly than I am, but it's in the appendix at page 687. And if I can take it from subparagraph 5 near the top of the page, the pleading was as follows. Unless and until the 2050 target is amended following the proper processes under the Climate Change Act 2008, the correct approach is to consider existing domestic legal obligations and policy commitments, and this is what the ANPS does. The relevant domestic legal and policy commitments being those found principally in or set under the CCA 2008 itself and the APF. The Secretary of State and his officials did not ignore the Paris Agreement. That's why we take slight issue with the use of the word disregard by Plan B. They did not ignore the Paris Agreement, or that there would be emerging material within government evidencing developing thinking on its implications. But it was concluded that such material should not be taken into account. In other words, it was not relevant, since it did not form an appropriate basis on which to formulate the policies contained in the ANPS. This included for the reasons set out in paragraph 34 above. And if you go back either now or later to page 673 of the bundle, that's paragraph 34, and you can see a number of reasons there set out concerning the nature of the Paris obligations, the dualist legal system, the advice of the Commission on Climate Change, the Plan B review, and the further commissioning of advice from the Commission, the procedure for amending, and the significance of the future process when development consent is applied for. So all those factors referred to by reference. Those reasons relate to the nature of the obligations set out in the Paris Agreement, its effects in domestic law as an unincorporated international treaty, and to the fact that as at the date of designation of the ANPS, the CCC's views on the implications of the Paris Agreement had not yet been sought, let alone received. As the government's statutory advisor on matters relating to climate change, the CCC has a critical advisory role in relation to the setting of relevant policy by government. The above facts demonstrate why emerging material within government evidencing developing thinking on the Paris Agreement was not so obviously material that the Secretary of State was obliged to take it into account. And indeed, the clear statutory indications are that such matters were not intended by Parliament to be considered. Then picking it up at 8, the assessment that such material did not need to be considered was thus a matter preeminently for the Secretary of State to determine, including having regard to the fact that any future change of policy could be dealt with via a review of the ANPS, or would have to be considered at the point that an application for a DCO was determined. The claimant's arguments put in the above context amount at their highest to an argument that the Secretary of State could have but did not take into account developing areas of climate change policy. Then this last sentence, there is no error at all in the Secretary of State exercising his discretion not to consider these matters, assuming such discretion existed and was not in fact impliedly excluded by the terms of the Planning Act 2008. And then the concession at 9, accordingly the Secretary of State will not pursue any, well, perhaps helpful narrowing of the issues is a better way to look at it, but whichever you call it, the Secretary of State will not pursue any discretion argument that there A, was no emerging material within government evidencing developing thinking on the implications of Paris, or B, that such material would highly likely have made no difference to the decision to designate the ANPS. There is no need for him to do so, as the argument that he was obliged to consider such material in the first place is hopeless and should be refused permission. But the Secretary of State was saying, in effect, that he had concluded, having thought about it, that Paris should not be taken into account, since as a developing area of climate change policy, it did not form an appropriate basis on which to formulate the ANPS. And that he accordingly did not submit either that there was no emerging material within government on the implications of Paris, or that such material would highly likely have made no difference to the decision to designate. And the concession, if that's what it was a very limited one. I'll make a few points on that. First, it stated in terms that the government did not ignore or disregard Paris. It thought about it, and we say rationally decided not to take it into account on the basis that a decision on airport capacity needed to be made on the basis of existing law and policy, rather than developing thinking on the implications of an international agreement. Secondly, it circumscribed the scope of argument and the scope of disclosure by indicating two submissions that the Secretary of State did not make because, as he put it in 62.9, there is no need for him to do so. But thirdly, he was not conceding that Paris or its associated materials would have made a difference to the decision to designate had they been taken into consideration. He is not even conceding that it might, or they might have made a difference, as Friends of the Earth claims at 11b. He's simply saying that he made no submission to the contrary because he didn't need to. Then fourthly, nor is the concession relevant to ground 3 or to ground 4, at least as it concerns non-CO2. Ground 3 is a formal and procedural obligation, this is the directive ground, to identify and communicate the existence of relevant information about international agreements and other things. That is reasonably required. It's not about the material that you've accumulated when considering its consequences, and it's not about what effect that material may or may not have had on your decision. And ground 4, of course, is not about the Paris Agreement at all, but about non-carbon dioxide, at least in its principal part. I'll come back to that point at the end when dealing with relief under ground 5, because it may have a bearing on the different situation of grounds 3 and 4. I took the court to the pleaded concession in some detail because those paragraphs are of general relevance to this appeal. But to save me coming back to them when I develop my submissions on ground 2, may I also ask the court to note their particular relevance to the first part of our appeal on ground 2. The issue of whether the Court of Appeal had a basis for saying, as it said in the last sentence of 236, that, and I quote, he did not even consider whether to take the Paris Agreement into account as a matter of discretion, close quotes. And in our submission, that is simply not consistent with the way the Secretary of State's case was pleaded and put in evidence. I now come to the applicable legislation. I know it will be familiar to many of your lordships and your ladyship, but I'd just like to show you the bits that matter. The laws contained in 2 statutes, which as the Divisional Court pointed out at 644 to 646, were interlinked. Indeed, they went through Parliament at the same time and received royal assent on the same day in 2008. I'll start with the Planning Act and address, as I do so, the debate that you've seen in the written cases about another central element of the case, the interrelationship between a national policy statement and a development consent order, which is the next stage along the line. The Planning Act starts at 1962 of the electronic bundle. But by way of introduction to the Act, if you have it handy, I propose not to go directly to the relevant provisions, although you may find it useful to have them open, but rather to go to paragraphs 20 to 40 of the Divisional Court's judgment, where they are not only introduced, but set in their historical context. The relevant sections are more briefly recited at 37 to 44 of the Court of Appeal. And this section of the Divisional Court's judgment is a reminder that highly experienced planning judges, Mr. Justice Holgate and Lord Justice Lindblom, were sitting both at first instance and on appeal in this case. So going to paragraphs 22 to 24 of the Divisional Court, they deal with the old system of planning inquiries, the defects in that system as they were identified by the White Paper of 2007, and the desirability of national policy being clearly set out at the start of the process for the benefit both of planning inspectors and of developers needing to make long-term investment decisions. Paragraph 25 deals with the function of the NPS as it was envisaged in the White Paper to address in advance of any inquiry such issues as whether there is a case for infrastructure development, or the types of development most likely to meet the need for additional capacity. And you see that the NPS, proposed NPS, was described in the white paper as the primary consideration in the determination of an application for a DCO, and more on that later, although other relevant considerations should also be taken into account. And to provide democratic accountability, it was said that NPSs should be subject to parliamentary scrutiny. Then at 27 to 28, we come on to the content of an NPS, governed in material respects by sections 5 and 10, which of course form the centerpiece of both respondents' cases. Section 5.8 is set out. Part of the requirement to give reasons for the policy set out in the statement, which is section 5.7, is that those reasons must, in particular, include an explanation of how the policy set out in the statement, the planning policy, takes account of government policy relating to the mitigation of and adaptation to climate change. So that's the subject matter of ground 1. Then section 10, which, as you can see, applies to the Secretary of State's functions under sections 5 and 6. Section 5 is the designation function. Section 6 is the function of review. 10.2, the Secretary of State must, in exercising those functions, do so with the objective of contributing to the achievement of sustainable development. And that term is defined at 635 of the Divisional Court's judgment, as Friends of the Earth rightly say, paragraph 14, by reference to the Brundtland definition and also the National Planning Policy framework, the 3 overarching objectives being the environmental objective, the economic objective, and the social objective. And going back to section 10, back at paragraph 28, for the purposes of subsection 2, the Secretary of State must in particular have regard to the desirability of mitigating and adapting to climate change. And sections 10.2 and 10.3 are, of course, the subject matter of ground 2, but also the gateway by which ground 4 was pleaded by Friends of the Earth and comes into consideration. Sections 5.8 on the one hand and 10.2 and 3 on the other have similarities, but a different focus. We agree with Friends of the Earth, 15, that Parliament should not be taken to have legislated twice for the same duty. Section 5 is directed to taking account of government policy relating to climate change. Section 10 requires the Secretary of State to have in mind the objective of contributing to the achievement of sustainable development by having regard to the desirability of mitigating and adapting to climate change. Incidentally, the ... conceals one other factor whose desirability must be had regard to, that is the desirability of achieving good design. So section 10 is not limited to government policy, but it is, in our submission, an obligation of a relatively weak and indirect nature. That's why at footnote 7 to our case, we respectfully questioned the description of these statutory duties by the Court of Appeal in the Packham case, the HS2 case, as specific duties. Going on to procedure, the basis for the NPS procedure is summarized at 30 to 32 of the Divisional Court. So you see there the requirement for an appraisal of sustainability, which I will call the AOS. That's also the report required by the SEA directive, the requirement for public consultation and parliamentary scrutiny. And as the facts of this case illustrate, these are very much more than simply formal requirements. There were 2 consultations on drafts of the ANPS and the appraisal and the AOS, launched respectively in February 2017 and October 2017. And as you see from 70 and 74 of the Divisional Court judgment, The first attracted more than 72,000 responses, the second more than 11,000. The opportunity for committees of either House of Parliament to scrutinise the proposed NPS was taken up in the Commons. It was considered at length by the Commons Transport Committee between November 2017 and March 2018, and its report was published alongside the government's response to it in June 2018. That's Agreed Statement of Facts and Issues, paragraph 14. The next stage is the application for development consent, which is another enormous exercise, and the statutory provisions which begin at 1967 of the electronic bundle are covered at paragraphs 33 to 39 of the Divisional Court's judgment. At 34 to 35, you see the requirements for pre-application consultation, applications accompanied by consultation reports, and post-application notifications. Then at 36, the examining process is summarized. You have the appointment of an examining authority. You have provision for the 6-month examination process, extendable if necessary, which will involve written representations, written questions from the examining authority, and various types of hearings, including issue-specific hearings at which interested parties may appear. And then you have the ability for the proposed DCO to be amended either by the applicant or by the examining authority, or indeed by the Secretary of State as decision maker. Then at 37, the determination of an application is dealt with under section 104. And just for your note, although it doesn't appear in the judgment, the power to grant or refuse consent is in section 114. But I'd like to take a little longer on section 104, because this goes to a point made repeatedly by Friends of the Earth, particularly, but not only, in relation to non-CO2, that matters not included in the ANPS are, and I quote, squeezed out of consideration at the DCO stage. And the references to Friends of the Earth's case on that are 5 to 8, 69A, 70, 76. The true position is a little broader than that. The relevant provisions are again set out at paragraph 37, if you prefer to look at them there. By 104.2a, the Secretary of State must have regard to any NPS which has effect in relation to development of the description to which the application relates. That is a relevant national policy statement. May I descend into the weeds for 30 seconds and explain what is meant by has effect in the context of this case. The ANPS it's at 1720, paragraph 1.40, I don't need to take you to it, is said to have effect in relation to the delivery of additional airport capacity through the provision of a northwest runway at Heathrow. But it's stated not to have effect in relation to other matters such as development at other airports. That's 141. Going on through 104.2, the Secretary of State must also have regard, D, to any other matter which the Secretary of State thinks is both important and relevant to the Secretary of State's decision. Then 104.3 says that the Secretary of State must decide the application in accordance with any relevant national policy statement, except to the extent that one or more of subsections 4 to 8 applies. So that is what is meant by the idea that the NPS provides the framework for the development consent application. But deciding an application, before we get to subsections 4 to 8, I make the point that deciding an application in accordance with a relevant NPS doesn't mean that it will necessarily be approved. And that's both because of the way the NPS itself may be worded, and it's also because of the succeeding subsections of 104 and indeed other sections of the Act. So the first point is that the NPS may itself indicate issues which are grounds for refusal of development consent. So, for example, in relation to carbon, 5.82 of the ANPS, its electronic document 1769, says any increase in carbon emissions alone is not a reason to refuse development consent unless so significant that it would have a material impact on the ability of government to meet its carbon reduction targets, including carbon budgets. In other words, if it would have a material impact on the government's ability to meet its targets and its carbon budgets, that is a ground for refusal that is still in accordance with the ANPS. And a failure to comply with a requirement of the ANPS could also be a reason for refusal. So at 576 of the ANPS, the previous page, 1768, requires the applicant to submit with the application an environmental statement that includes an assessment of the likely significant effects of the development, including on climate, broadly stated. Then moving on to the exceptions, or the subsections 104.4 to 8, and if they apply, the Secretary of State, or to the extent that they apply, the Secretary of State is relieved of its obligation to decide in accordance with the NPS. 104.4 is of interest. It applies if the Secretary of State is satisfied that deciding the application in accordance with any NPS would lead to the UK being in breach of any of its international obligations. 5, similarly, applies if the Secretary of State is satisfied that it would lead to him or her being in breach of any duty imposed on the Secretary of State by or under any enactment. 6, this subsection applies if the Secretary of State is satisfied that deciding the application in accordance with any relevant NPS would be unlawful by virtue of any enactment. I just pause to mention that the Human Rights Act 1998 will be one of those enactments. I'll come on to that when we deal with what Plan B has to say about that. 7, an important one, this subsection applies if the Secretary of State is satisfied that the adverse impact of the proposed development would outweigh its benefits. So a very broad formulation there. And 104.9, I don't think this is referred to in any of the cases. I may be wrong about that, but it's important. It says, for the avoidance of doubt, the fact that any relevant NPS identifies a location as suitable or potentially suitable for a particular description of development does not prevent one or more of subsections 4 to 8 from applying. The balance between 104.3 and 104.7 in our submission is particularly important. It allows objectors to identify the adverse effects that should outweigh the benefits, including the benefit of meeting need, that is identified in the ANPS. As stated earlier, by 104.2, the Secretary of State must have regard to any other matters which the Secretary of State thinks are both important and relevant to the Secretary of State's decision. The conclusions of the AOS or the ANPS can be overridden, as the ANPS itself emphasizes at 1.29, concluding that the benefits outweigh the harm, but accepting that this is subject to the assessment of the effects of the preferred scheme to mitigation and to its delivery. So in reality, representations can be, and I'm told in practice invariably are, made on a very wide range of issues at the DCO stage. What does that mean in the context of this case? That is dealt with in great detail by the Divisional Court at paragraphs 91 to 112 of its judgment, in terms with which no party took issue before the Court of Appeal, or indeed, so far as I can see, before this court. And I think the first point to note, I shan't take you all through that section, but the first point to note is that representations that relate to the merits of policy in an NPS may be disregarded in the examination and by the Secretary of State in determining the application for development consent. That's a point that the Divisional Court makes a little earlier on, in fact, just after, it's in paragraph 38 of the judgment, so just after it sets out 104, and reference is made there to sections 87, 94, and 106. They're electronic 2032, 2043, and 2065. What that means in practice is explained by the Divisional Court at 92, which is said at 110 to be common ground. So there are three matters of national policy which cannot be challenged in the DCO process because of those three sections. There is a pressing national need for new airport capacity in the southeast. The need should be met by the NWR scheme, and the assessments which an applicant for DCO will have to carry out and the planning tests that it will have to meet are set out in the ANPS. But that does not, of course, preclude other assessments and other tests being taken. But looking at the other side of the coin, other things may not be disregarded at the DCO stage. And the following may be argued at that stage within the framework of section 104 and without conflicting with those exclusionary provisions in sections 87, 94, and 106. The first, a point I've made by reference to ANPS 582, that the increase in carbon emissions would have a material impact on the ability of government to meet its carbon reduction targets, including its 5-yearly budgets. And since future carbon budgets will reflect the new statutory carbon target, the net zero that was enacted in 2019, the impacts of the proposal will be judged against budgets which have been approved having regard to that target, and hence the UK's obligations under the Paris Agreement. This really goes to the core of the way the case is put against us, particularly by Plan B, where they seek to draw a very binary distinction between the Climate Change Act target of 80%, discredited based on limiting global temperature increase to 2 degrees and so on, and the brave new world of Paris, which requires net zero, albeit incidentally not by 2050, by the second half of the 21st century, and which will be given effect by the new revised statutory target of 100% net zero by 2050. But it's really not as simple as that. And this point does show why this process adapts itself to the state-of-the-art targets and budgets. And those budgets, we can be sure from now on, will be approved in relation to that current law. We're sure, incidentally, the law won't be relaxed again because Paris requires that it's a one-way ratchet. The changes must be, as they put it, progressive. So that's an important point. Well, I'll come on to the question of international aviation emissions and how they're taken into account. The second thing that may be argued at the DCO stage is that the applicant has not complied with one of the assessments or planning tests that has to be carried out in order for a DCO to be granted, and that's 110, paragraph 110.3. Sorry, is that right? Yes, it is possible to argue that the applicant has not complied with one of the assessments or planning tests that has to be carried out in order for a DCO to be granted. Then thirdly, the grant of a development consent would lead to a breach of the UK's international obligations, 104.4, and no statement there that those obligations need to be specified in domestic law. This is a direct reference to international obligations. Fourthly, that the grant of development consent would lead to a breach of a statutory duty, 104.5. And then finally, that the adverse impacts in terms of climate change outweighed the benefits, 104.7, even where overriding the identification of the location of the development, 104.9, and that is dealt with in paragraph 91 of the Divisional Court's judgment, where the combined effect of 104.7 and 104.9 is considered. I'll go on to the question of review, which is an issue discussed at 107 to 109 of the Divisional Court's judgment. And review is governed by Section 6 of the Planning Act, it's page 1964. And the factors in deciding when to review an NPS are set out in Section 6.3 for review of the whole NPS, and Section 6.4 for a partial review of the NPS. And the terms are similar: significant change in circumstances, not anticipated, materially different. That's all summarized at 107 to 108 of the Divisional Court. 109 of the Divisional Court is important. This analysis would not preclude the making of an objection in the DCA process that there has been a change in circumstance since the designation of an NPS that affects the assessment of the adverse impacts of the proposed development itself and may cause the balance struck under 104.7 to come down against the granting of development consents. So you have, in a sense, these two parallel processes of the review and the DCO. Then the options after a review are set out at Section 6.5, and those options are to amend or to withdraw or to leave the statement as it is. Amendment, as you see from 6.6, has to be preceded by an appraisal of the sustainability of the policy set out in the proposed amendment. Then there are various consultation and publicity requirements summarized by the Divisional Court, paragraphs 67 to 77, and parliamentary requirements, which are set out at Section 6.7 of the Act. Then the Act goes on. I don't need to take you to it, but there's a lot about the parliamentary requirements in Section 9 as well. By Section 11, moving on through the Act, the Secretary of State may suspend an NPS pending review, and indeed the Secretary of State may suspend any part of an NPS pending completion of a review. That's Section 11.5. And then there are a number of provisions, finally, that, yes, I'm sorry, 11.5, I think 11 didn't get in, perhaps 13 didn't get into the bundle. They're both in the supplementary bundle, respectively at section, page 17 and 19. They're not of primary importance, but I didn't want the court not to have them. 11 is about suspension pending review. 13, a number of provisions allowing legal challenge by judicial review to decisions relating to Section 6 review. These include the ability to challenge a decision not to review, Section 13.2, a decision to carry out a review, 13.3, anything done or omitted to be done in the course of a review, Section 13.4, and decisions on completion of any review in Section 13.5. Going on to the Climate Change Act, the main provisions are summarized at 564 to 571 of the Divisional Court. That you may want to have it open at electronic 1898. Though there are two sections, 24 and 30, which I'd like to refer to briefly, which are in the supplementary bundle at pages 3 to 16. But I'll take this from the Divisional Court's summary. You see that at 565, Section 32, the establishment of the Commission on Climate Change. That's
I'm sorry, can you give us an electronic page reference for that, Lord Anderson?
Is this to the Divisional Court's judgment or to
yes,
the...
Yes, the Divisional Court, yes.
Right, I'm afraid I made the mistake of keeping mine outside that system, but you don't want to core. Of course, it appears in the hard copy bundles, but you don't want that. You want the electronic.
Oh well, I dare say if you can give us it in the hard copy, that will do.
396 is the page.
Thank you very much.
I'm very grateful to Lord Leggett. 396 Yes, I'm afraid I haven't. The only electronic document numbers I haven't noted are to the judgments of the Divisional Court and the Court of Appeal,
Right.
and to the agreed statement of facts and issues. So I'll perhaps be handed a note or something to remedy that. But here we are anyway at paragraph 565, or if you're actually looking at the Act, it's 1911. This is establishment of the CCC to advise on the 2050 target, that's at section 33, and to advise on the carbon budgets at section 34. Yes, I'm told 565 is on page 455 of the electronic bundle. Then going straight on from there, we come to section 1, key section, mandatory target for the reduction of UK carbon emissions. And the section is set out as it stood at the time of the designation decision. So you have the target of at least 80% lower than the 1990 baseline. The word UK has been omitted, I assume in error. It should say the net UK carbon account for the year 2050. And that's at 1898 of the bundle. If you look over the page, the Divisional Court says, quoting the CCC, that the 2050 target, that's the 80% target, was derived as a contribution to a global emissions path aimed at keeping global average temperatures to around 2 degrees above pre-industrial levels. And there's no doubt about that before this court any more than there was before the court below. That's stated at the end of 566. I'd like to come back in a moment, though, to what the target is for exactly. There's a slight wrinkle there. 567 summarizes the provision for amendment of the target if there are significant developments. There is a statutory mechanism which involves the Secretary of State being satisfied there have been significant developments in scientific knowledge or in law or policy. The Secretary of State has to obtain and take into account advice from the CCC, and there's a parliamentary procedure. And that is exactly what happened when that percentage was amended on the CCC advice in 2019. Then 568 says what the target relates to and suggests that it relates to carbon only. I'm afraid there is another short excursion into the weeds because, with great respect, that is not quite accurate. It may be colloquially accurate, but it's not quite accurate. And I need to take you to, first of all, section 27, which is at the supplementary page 9, which defines what is meant by the net UK carbon account. That's the phrase used in section 1. The net UK carbon account means the amount of net UK emissions of targeted greenhouse gases for the period, and then it's explained what net means. What is a targeted greenhouse gas? Well, for that, still in the supplementary bundle, we have to go back to section 24. It's at page 3. And you'll see that in this part, a targeted greenhouse gas means 6 gases that are set out there, the 6 gases in the Kyoto Protocol, sometimes called the Kyoto gases. The big one, of course, is carbon dioxide. The others, I think it's common ground, are not relevant to aviation at all, save for nitrous oxide, which is relevant at the margins. That's a point we make at 102 of our case, where we deal with the Kyoto gases and state that, on the authority of the DFT, that carbon dioxide makes up about 99% of the UK's Kyoto greenhouse gas emissions, with the other 1% coming from nitrous oxide. So it may not be strictly accurate to refer to this obligation as relating only to carbon. It relates to those 6 gases, of which carbon is by a very long way the most significant. Incidentally, there's a power, as you see, to designate in 24G, 24.1G, other greenhouse gases. My understanding is that power has not been designated. Going on through the Divisional Court, at 569, paragraph 569, this is page 456 of the bundle, we have the carbon budgets that are provided for in section 4 at 1902. And as it's stated, summarized here, the Secretary of State is required to set for each succeeding period of 5 years, at least 12 years in advance, an amount for the net UK carbon account, the carbon budget, and ensure that the net UK carbon account for any period does not exceed that budget. And as it's stated there, the carbon budget for the period including 2020 was set to be at least 34% lower than the 1990 baseline. Well, we're now on to well, there's been 2 more budgets set since then. I'll give you the references without taking you to them. It's electronic bundle 914 and 1539. The 4th carbon budget covers the 5-year period 2023 to 2027. It provides for a 50% reduction on 1990 levels by that period, and it was set in 2011. The 5th carbon budget covers the period 2028 to 2032. It provides for a 57% reduction on 1990 levels by that period, and it was set in 2016. And applying the scheme in section 4, the 6th carbon budget cover the period 2033 to 2037 has to be set by the end of June next year. Next year, of course, being a significant one in the climate change world because of the COP26 summit due to be held in Glasgow in November. And as we'll see in a moment, before Paris, what you see is people setting out their stall in terms of what reductions they're prepared to offer in advance of the summit. And no doubt some big decisions will have to be made about that 6th budget before next June. Section 5, which is at 1903 of the electronic bundle, deals with carbon budget levels, amendable under section 6, various procedures at sections 7 to 9. None of that, I think, very important. Where does aviation fit into this? Well, emissions from international aviation, you get this from section 30, which is in the supplementary bundle at page 14. Emissions of greenhouse gases from international aviation or international shipping do not count as emissions from sources in the United Kingdom for the purposes of this part. We're still in part 1 of the Climate Change Act, except as provided by regulations made by the Secretary of State. So emissions from international aviation as defined by the Secretary of State, and that definition is basically a definition of flights which take off abroad, land abroad, or both, are not emissions from sources in the UK for the purposes of Section 1. And the Divisional Court very clearly explains how this is interpreted, it explains the position of international aviation and why, although it's not part of the target in Section 1, international aviation is included in practice as part of the carbon budgets. And that's explained at 570 to 574, starting in particular at 572. But before we go there, we might, yes, Section 10 is set out, 10.2 is set out at 570. And although international aviation is not within the carbon target, it is taken into account in the setting of carbon budgets. So that's the point made at 570 by reference to Section 10.2. And the reference to 10.2 is at 4.5. No, sorry, that's a reference to the Divisional Court is at 456. Reference to 10.2, I don't immediately have, but, well, yes, it's set out here. Yeah. How it's done is explained at 572 to 574 by reference to the Secretary of State's evidence. This is from Ms. Lowe, who explains it. I think she was in charge of the airport capacity program at the Department for Transport at the relevant time. The CCC has interpreted that as requiring the UK to meet a 2050 target, which includes these emissions. The CCC has advised that to meet the 2050 target on that basis, emissions from UK aviation, domestic and international in 2050, should be no higher than 2005 levels. In other words, 37.5 million tons of CO2. That's referred to by the claimants as the aviation target. Then the policy framework explains that the government decided not to take a decision on whether to include international aviation emissions in its carbon budgets, simply leaving sufficient headroom in those budgets consistent with meeting the 2050 target, including such emissions, but otherwise deferring a decision for consideration as part of the emerging aviation strategy. The aviation strategy is due to re-examine how the aviation sector can best contribute its fair share to emissions reductions at both UK and global level, due to be finalised and adopted later in 2019. Well, we're now till 2020, and I have no up-to-date information on that. The restriction of aviation emissions to 37.5 megatons not having been adopted by the government, but being assumed by the CCC for planning purposes, the Secretary of State doesn't like the term aviation target, prefers planning assumption. So one sees the sensitivities there. But the Divisional Court refers to it as aviation target. Yeah. I'm so sorry, yes.
I think you said a moment ago, but I may not have taken it in properly, that the definition of international aviation emissions is flights into the United Kingdom. If that's correct, is there some international arrangement on this? Because otherwise you'd be counting the same emissions twice if they were counted both by the place where the aircraft takes off and where it arrives.
Yes, I'm so glad that I asked Mr. Humphreys exactly that question last night, and he provided me with a statutory instrument so dense that I'm afraid I balked at seeking to put it before the court. But may I tell you where the definition was adopted? It's in the Climate Change Act 2008, brackets 2020 Target, Credit Limit and Definitions Order 2009, Statutory Instrument 2009 number 1258. And I'll read you, great respect to parliamentary drafters, I'm sure it would have been impossible to do it any more shortly, but may I read you what international aviation consists of? A, the whole of any flight which one begins at an aerodrome in the United Kingdom and ends at an aerodrome outside the United Kingdom. So it doesn't matter, so it begins in the UK, ends outside. Or two, begins at an aerodrome outside the United Kingdom and ends at an aerodrome in the United Kingdom, regardless of whether the flight includes one or more interim stops at aerodromes in the United Kingdom. And B, the whole of any flight which begins and ends at aerodromes outside the United Kingdom. So a flight between Australia and Bali would also constitute international aviation. The limiting factor in the definition, of course, is the word UK. And my understanding is that that is interpreted by reference to where the, I'll be corrected if I'm wrong, where the bunkering takes place. I'm being a puppet here for Mr. Humphreys, but who understands these things. But you attribute to the UK the bunker fuel that is bought here. So that's why we're not too troubled about flights between Australia and Bali. Because we can produce that for the court if it would help. We could put it onto the electronic bundle. Very, very, very happy to do that. We're approaching the break, and I think I can get there having finished the legislation. So may I press on for yes, in fact, I think yes, we've almost finished this on international aviation. The Divisional Court at 574 says that with respect to the aviation target, the CCC advised that if aviation emissions at 37.5 were included in the 2050 aggregate carbon target, this target could be achieved through reducing emissions in other sectors by 85% on 1990 levels. And that they thought was at the limit of what was feasible. And then after 575, the story is told about the concerns that started to emerge in 2010 as to whether 2 degrees was going to be enough, and the result of that was Paris. Well, if that is a convenient moment, I'd like to
Yes.
go on simply to look at Paris and its sequels after short break, if your lordships and your ladyship want one,
Yes.
and then go to my submissions.
Thank you very much, Lord Ranson. We'll adjourn just now and resume in about 5 minutes' time. Now, I think we're ready to resume. So, Lord Ranson, I'll invite you to continue.
Thank you, my lord. I was asked before the break about how international aviation is defined, and I referred to the statutory instrument. I also referred to the mechanism by which the Committee on Climate Change seeks to attribute that aviation to the UK rather than other countries. And I wonder if I could just take you to one document on that, which is in the bundle. It's at page 865. This is the Committee on Climate Change document in which the 37.5 megatons was adopted by them as their figure for UK aviation carbon emissions in 2005. If you look at 866 in the middle of the executive summary, they state that that estimate was on a bunker fuels basis. That's where we get bunker fuels basis. If you go on in that document, and I regret that page 39 isn't in the bundle, we can certainly produce it if it's of interest, but there's a box in the report in which the CCC notes that there are alternative approaches to measuring UK aviation emissions. So yes, you could do it by bunker fuel sold in the UK. You could do it by airline nationality. You could do it by international departures and arrivals on an aircraft basis. This may be Lord Leggett's point. Emissions of outbound flights from the UK would be attributed to the UK, while emissions of the return flight would be attributed to the destination country. Or they said you could do it on a passenger basis. Emissions of outbound flights from the UK adjusted by a passenger kilometre index to reflect seat bandings of different flights. Well, they went for the bunker fuel basis. But the broader point here is that by its nature, and the clue is in the word, international aviation is international. And you will see initially in the Kyoto Protocol, but on many occasions since, the recommendation being that this issue be pursued so far as possible at an international level through ICAO. And that is something that the government is committed to doing. But it's fair to say that they're also committed to re-examining generally how the aviation sector can best contribute its fair share to emissions reductions at both the UK and global level. That's in the DFT aviation, that's in the document at Agreed Statement of Facts and Issues, paragraph 34. Could I go back on one other thing before I move on to Paris? When I was taking you through the Planning Act, I referred to section 104. I meant to refer also to section 120 of the Planning Act. It's at page 2085 of the electronic bundle. And that's the section stating that the DCO will be granted, or may be granted, I think in practice always is granted, subject to controls in the form of requirements. These are the equivalent of planning conditions, which may impose constraints on how the expanded airport could operate, including carbon emissions. So the DCO stage it does not involve a binary choice between granting the application as made or refusing it. A case can be made at the DCO stage that particular requirements should be imposed, for example, requiring measures to be taken in respect of emissions, whether carbon or non-carbon, to achieve climate change objectives. And indeed, the ANPS itself makes it clear that the adequacy of mitigation measures will be a material factor in determining a DCO application. That's at ANPS 583. Yes, and I'm reminded that the DCO will nearly always be a statutory instrument. I think I showed you the provision on parliamentary procedure, so those requirements will have the force of law. Can I go on to the Paris Agreement and its sequels? There is a fearsome statement of facts and issues in this case. It sets out the various documents that are considered relevant by one or more of the parties to this appeal, not always by all. And it would not be helpful to attempt a comprehensive run through. but I would like to take the court to a small number of those documents. The Paris Agreement, then the advice that was given to government on compliance with the Paris Agreement, and then the action that was taken up to and including the ANPS. And just for your reference, this is in broad terms the material that was covered by the Divisional Court at 576 to 601, a section which had the blessing of the Court of Appeal at 188 to 189. I'm sorry, do you want the electronic references to that?
No, that will do, thank you.
Right. And the documents, all those documents were considered by the courts below, and they're relevant in particular to the assessment of whether it was obviously material and so on to have regard to the Paris Agreement in the ANPS. So the Paris Agreement is at 2131. The precursor agreements, which I don't take you to, are summarized in paragraph 10 of our case, and also 24 to 27 of the Statement of Facts and Issues. Just to summarize on those very briefly, the UNFCCC, which is at 2422, was adopted at the Rio Earth Summit in 1992. It's a framework convention which set out a broad objective of stabilization of greenhouse gas concentrations in the atmosphere at a level that would permit dangerous anthropogenic interference with the climate system. That's Article 2. There was then the Montreal Protocol, which I think we don't need to bother with, 1987. That's about chlorofluorocarbons. Then you have the Kyoto Protocol of 1997, which entered into force in 2005. That's at 2438. That sets specific country-by-country targets for the period 2008 to 2012. And Article 2.2 of the Kyoto Protocol, which is at 2440, names ICAO. Sorry, I'll just call it up. If I can. 2440. Yes, this is the annex, Article 2, sorry, Article 2.2 of Kyoto. The parties included in Annex 1 shall pursue limitation or reduction of emissions of greenhouse gases not controlled by the Montreal Protocol, so that's not chlorofluorocarbons, from aviation and marine bunker fuels, working through the International Civil Aviation Organization and the International Maritime Organization, respectively. So that's an acknowledgement by the signatories to the Kyoto Protocol to the UNFCCC that when you're looking at these international modes of transport, it really makes sense where possible to act internationally. My friend Mr. Wolf makes the point quite correctly. He cites an Advocate General from the European Court saying that doesn't mean they can only act through ICAO, but nonetheless they are mandated to act through ICAO by Article 2.2. Then the Doha Amendment, adopted in 2012 but never entered into force, that's at 2432. That would have tightened the national carbon targets and extended them to the period 2013 to 2020. But as I say, it never entered into force. So now we come to Paris, which is at 2131, Statement of Facts and Issues 28. It was adopted in December 2015, signed the following spring, ratified by the UK, and entered into force in November 2016. And you'll have seen its main provisions already, but may I take you through the particularly important ones? You'll see that at 2132, the parties to the agreement are parties to the UN Framework Convention on Climate Change, and that they recognize the need for an effective and progressive response to the urgent threat of climate change on the basis of the best available scientific knowledge. Then going to Article 2, this agreement in enhancing the implementation of the convention, including its objective, and you'll remember the objective in Article 2 of the UNFCCC, stabilizing greenhouse concentrations at a level that would prevent dangerous anthropogenic interference with the climate system, aims to strengthen the global response to the threat of climate change in the context of sustainable development and efforts to eradicate poverty, including by, wording of 2.1a is quite important, holding the increase in the global average temperature to well below 2 degrees centigrade above pre-industrial levels, and pursuing efforts to limit the temperature increase to 1.5 degrees above pre-industrial levels, recognizing that this would significantly reduce the risks and impacts of climate change. So 2 points on that. One, it's not time limited. And no doubt we all hope that global average temperatures will never rise by more than these amounts above pre-industrial levels. That is what the parties aim to do. But the second point, one cannot say that this has substituted 1.5 for 2. It's not as simple as that. The aim is to hold the increase to well below 2 and to try to limit it to 1.5. Then going on to 2.2, you see the agreement will be implemented to reflect equity and the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances. And this is a very important theme of the Paris Agreement, because unlike Kyoto and Doha, which imposed specific targets on specific countries, Paris did not do that, as we will see. Then Article 3, each party is to undertake and communicate as nationally determined contributions, the so-called NDCs, to the global response to climate change, ambitious efforts as defined in Articles 4, 7, 9, 10, 11, and 13, with a view to achieving the purpose of this agreement as set out in Article 2. The efforts of all parties will represent a progression over time, and then more reference to developing country parties. So this is the concept of NDCs. And Article 4, in order to achieve the long-term temperature goal set out in Article 2, parties aim to reach global peaking of greenhouse gas emissions as soon as possible, recognizing that peaking will take longer for developing country parties, and to undertake rapid reductions thereafter, so as to achieve a balance. This is net zero. So as to achieve a balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases in the second half of this century. So this one does have a time constraint, but it is not 2050. It is in the second half of this century, no more precise than that. And here we find the first specific reference to NDCs. It's the one relevant to this case. It's the one relevant to greenhouse gas emissions. Each party shall prepare, communicate, and maintain successive NDCs that it intends to achieve. Parties shall pursue domestic mitigation measures with the aim of achieving the objectives of such contributions. Then Article 4.3, I think a point I mentioned earlier, each party's successive NDC will represent a progression beyond the party's then current nationally determined contribution. So that's the ratchet. And Article 4.4, developed countries should undertake economy-wide absolute emission reduction targets. Well, as at the time, of course, was the 80% by 2050. So there's more provision over the page on 2136 about the communication of NDCs under Article 4. So, for example, Article 4.9, you have to communicate one every 5 years. The conference of the parties should consider timeframes. You can adjust them. 11, maintained in a public registry. And then 16, parties including regional economic integration organizations and their member states that have reached an agreement to act jointly shall notify the Secretariat of the terms of that agreement, including the emission levels allocated to each party within the relevant time period. 17, each party to such an agreement shall be responsible for its emission level. And 18, if parties acting jointly do so in the framework of something like, for example, the EU, which is itself a party to this agreement, and the EU this was a mixed agreement, so the UK signed it, so did the EU. Each member state of that organization individually and together with the organization shall be responsible for its emission as set out. You saw reference back in Article 3 to other types of NDC. They relate to matters such as transparency and contribution to less developed countries and so on. I don't think they have any bearing on this case. The government set out its obligations under Paris in its skeleton argument for the divisional court. It's at 556 of the electronic bundle, and also of my rather old-fashioned paper bundle. Paragraph 160. I don't know whether the court has that
Yes.
paragraph. Thirdly, while the government is fully committed to the objectives of the Paris Agreement, the legal obligation on the parties is to prepare, communicate, and maintain NDCs to reduce net emissions, with a view to achieving the purpose of holding global average temperature increases to well below 2 degrees and pursuing efforts to limit them to 1.5 degrees. This is not the same as a legal duty or obligation for the parties individually or collectively to ensure that no more than these maximum temperature increases are reached. This too reflects the position of the CCC. There is also a collective long-term goal for near net zero emissions in the second half of this century, which all countries will work together to achieve. Notwithstanding the common objective, there is no legal obligation on any one party to adopt a binding domestic target to ensure that a target of 1.5 or even one well below 2 is met by 2050. Thus, for example, and I just, there's reference here to something I just like to go into, which is how the UK's NDC was communicated to the United Nations. And of course, at the time we were members of the EU, and the communication was done for us on an EU basis, which I'll take you to. But perhaps just have in mind the last sentence of this paragraph, which says, thus, for example, the NDC set by the EU, which covers the UK, has set a binding target of achieving 40% reduction of 1990 emissions by 2030. So that is strictly our NDC communicated for us by the EU, 40% reduction. This is less stringent than the target already set under the CCA 2008. That's in the 5th carbon budget, 57%. So can I deal with how the NDC was communicated? This is not in dispute between the parties. We explain it at 47.3 of our case and footnote 21 at the same paragraph. Friends of the Earth explain it at footnote 5. Not in dispute that the UK's NDC was communicated to the UN by the European Union on the UK's behalf and that of the EU. And this is, in a formal sense, the NDC communicated on behalf of the EU. The way the burden was shared between the EU member states is set out in a thing called the burden sharing regulation. That's at electronic 2415, tab 26. And I'd just like to start with the recitals. I think I made the point that there was a bit of a bidding war going on before Paris, and the EU in particular tried to get its decision in early so as to influence the discussions at Paris during 2015. And you see from the first recital that the Council, as early as October 2014, endorsed a binding target of at least a 40% domestic reduction in economy-wide greenhouse gas emissions by 2030, compared to 1990. And then this target was reaffirmed after Paris. The second recital, the conclusion stated the emissions reduction target of at least 40% should be delivered collectively by the Union in the most cost-effective manner possible, with the reductions in the European Union emissions trading system and non-emissions trading system sectors amounting to 43% and 30% respectively by 2030 compared to 2005. All sectors of the economy should contribute to achieving those greenhouse gas reductions, and all member states should participate in this effort, balancing considerations of fairness and solidarity. The methodology to set the national reduction targets for the non-ETS sectors, with all the elements applied in the decision number 406 of 2009, should be continued until 2030, with efforts distributed on the basis of relative gross domestic product per capita. All member states should contribute to the overall union reduction in 2030, with a target spanning from 0 to -40% compared to 2005. So there are, and then further on at recital 22, there's reference to another regulation called the Land Use Regulation. But the upshot is there are really three mechanisms applied by the EU in order to achieve the 40% reduction that was their NDC, and by extension our NDC as lodged with the UN. There are the 43% reductions to be achieved by the emissions trading system. That covers aviation within the European Economic Area, but not outside it. And that's done, I don't think the details matter, but it's a cap and trade system. There is a cap on the total amount of certain greenhouse gases that can be emitted by sectors within the system. And within the cap, companies receive emissions allowances, which they can trade with one another as needed. They can also buy international credits for carbon reduction projects around the world. So that's one basis. The second basis is the Land Use and Forestry Regulation, 2018-841. And then the third, the 30%, is via the non-emission trading system sectors, distributed, as indicated in the recital, on the basis of GDP, the headline being that if you're rich, you're expected to contribute more. So if I take you to Article 4.1 of the regulation, you see that each member state shall in 2030 limit its greenhouse gas emissions at least by the percentage set for that member state in Annex 1. And if you go to 2428, you see Annex 1, and we had to reduce ours by 37% in relation to that part of the enterprise. So those figures, and it's not an exact comparison. You've got to factor in the ETS as well as the non-ETS sectors. But in our submission, the Secretary of State was entirely justified to make that point in his skeleton argument by reference to the fourth and fifth carbon budgets that the EU's NDC notified on our behalf was less ambitious. We're looking at 50% on the fourth carbon budget by 2023 to 2027, and by the carbon budget that spans 2030, which is a fifth carbon budget, 57%, and that allows the headroom of 37.5 megatons for international aviation. What about domestic measures? Article 4.2 of Paris 2135 also, as you saw, required parties to pursue domestic mitigation measures with the aim of achieving the objective of their NDCs. And the UK had already implemented domestic measures in the form of the statutory carbon target and the system of 5 yearly budgets. So although Section 1.1, we quite accept, is not formally the NDC itself, it is the nationally determined UK measure required by Paris that contributes to the objective of that NDC and thereby to the broader objective of Paris Agreement. We say in our case on 2 or 3 occasions that at the time of the contested decision, the UK's NDC was, or paragraph 44, we say it represented its statutory carbon reduction target as enshrined in Section 1.1. That phrase doesn't qualify, shouldn't be read as qualifying what we say in paragraph 47. In the formal sense, the NDC was notified for us by the EU. In the practical sense, that is the UK's contribution to those objectives. So the important points on this, to summarize, are first that an NDC was notified to the UN on our behalf by the EU. Secondly, no one suggests, this is important, no one suggests that we are failing to comply with the terms of that NDC notified by the EU under the Paris Agreement. Thirdly, our national targets, as expressed in and under the Climate Change Act 2008, are already more ambitious than the NDC lodged on our behalf. And fourthly, consistently with Paris Article 4.3, any further NDC notified in the future must represent a progression beyond that. May I now come on to the sequels to Paris and how UK climate change policy developed after Paris. And I can take you first of all to the agreed statement of facts and issues at paragraph 42, where you see the statements of Andrea Leadsom and Amber Rudd, both government ministers, in the early part of 2016. So Andrea Leadsom is quoted as saying that the government believe, sorry, page 76 if you're doing it on the electronic bundles. Andrea Leadsom said that the government believe we will need, I emphasize that, to take the step of enshrining the Paris goal of net zero emissions in UK law. The question is not whether, but how we do it. And there is an important set of questions to be answered before we do. So yes, of course, there's a commitment to putting net zero emissions into UK law. Net zero emissions, of course, by the second half of the 21st century. But the question is how we do it, and an important set of questions to be answered before we do. A great deal of weight is placed on this statement by the Court of Appeal and by the respondents. In our submission, this is a very carefully caveated statement. And similarly, the same briefing note, one suspects, referred to by Amber Rudd, Secretary of State for Energy and Climate Change, a few days later. Then we had an important document for this case, which was the CCC report of October 2016. That's at 1358 of the electronic bundle, and it's referred to at 581 of the Divisional Court and 43 to 48 of the agreed statement of facts and issues. But I'll take you to the document at 1358. It's called UK Climate Action Following the Paris Agreement. And the explanatory memorandum, sorry, the executive summary on the first page says the Paris Agreement marks a significant positive step. Our conclusions are as follows. First bullet, do not set new UK emissions targets now. The UK already has stretching targets. Achieving them will be a positive contribution. In line with Paris, the government has indicated it intends at some point to set a UK target for reducing domestic emissions to net zero. We have concluded it is too early to do so now, but setting such a target should be kept under review. The 5-year cycle of pledges and reviews created by Paris provides regular opportunities to consider increasing UK ambition. Then they recommend vigorous pursuit of measures required, flexibility to go further, a strategy to remove greenhouse gases from the air, because of course you're not going to get to net zero simply by emitting less. I mean, there are some sectors, and they single out here aviation, agriculture, and parts of industry, where however clever you are with revolutionary new fuels and aircraft design and all the rest of it, some emissions are going to remain. So reference here to how you get to net zero, the other side of the balance, greenhouse gas removal options, and some examples given there. And then in the tailpiece to this summary, we agree with the government's intention to set a new target in future that reflects the global need to reach net zero emissions. However, to be credible, it needs to be evidence-based, accompanied by strong policies to deliver existing targets and a strategy to develop greenhouse gas removals. Early action will allow the UK to fulfill its commitment under the Paris Agreement and position it to take a competitive advantage. Then 1364, if you could move on, sections well, on the previous page, 1363, you see the need for strategies for hard-to-treat sectors, and aviation, of course, is one of those. Then at 1364, implications for UK policy priorities in the nearer term. The third paragraph, we recommend the government does not alter the level of existing carbon budgets or the 2050 target now. Then at the bottom of the page, we will advise on whether to set a new long-term target, emphasize the word whether, or to tighten UK carbon budgets as and when these events or any others give rise to significant developments. And those events included, as you see from the first bullet, 2018, the IPCC special report. So that's what they say there. Then at 1368, you see, well, again, on the previous page, 1367, there's a heading, the UK 2050 emissions target and associated warming. The second bullet there, we based our advice on a proposed global objective to keep central estimates of global temperature in 2100 close to 2 degrees above pre-industrial levels. So that's the basis on which the Climate Change Act original target was set. And they set out what their estimates were. And they say on 1368, the UK 2050 target is potentially consistent with a wide range of global temperature outcomes. The IPCC suggests a lower temperature could be achieved to the level of global emissions we assumed in 2050. And perhaps we were too pessimistic. This relies on the option of reaching net negative global CO2 emissions after 2050, which was not included in our scenarios. We do not yet know if such cuts will be feasible. Then first bullet, the most recent IPCC assessment, drawing on a wider range of more detailed evidence than our 2008 report, concluded that paths consistent with at least a 66% chance of staying below 2 degrees centigrade would have global emissions of 1529 gigatons. Hence, the global level of 20 to 24 billion tons underpinning the UK 2050 target, that is the existing 80% 2050 target, could be consistent with a lower central estimate of temperature than we assumed, i.e. below 2 degrees centigrade. Then at the bottom, some explanation, and at the bottom of that paragraph, in summary, the UK 2050 target was set to align to around a 50% likelihood of limiting temperature increase to 2 degrees centigrade, but could be consistent with around a 66% likelihood. Then completing the point by going to 1372, you can see how they correlate this to Paris. In the middle of that page, in order to assess global emissions paths, we interpret the temperature aims in the Paris Agreement to range from, at minimum, a 66% likelihood of staying below 2 to, at maximum, a 50% likelihood of staying below 1.5. So that's how they translate the Paris aims into their modeling. And they're saying that the existing target could be consistent with around a 66% likelihood. Hence the caution. We will advise on whether, and if so, how. And in any event, don't set emissions targets now. So I think we're criticized for putting that explanation on, or that interpretation on the document. But there's a very short way to seeing that this is exactly what the CCC meant, because the CCC itself said so when it intervened in the Plan B judicial review that I mentioned right at the outset. The judicial review of the non-changing of the target that was brought at the end of 2017. And this is at 1811 of the bundle. This is the response to the claimant's reply to the summary grounds. I don't think it's dated, but you can see that the commission hearing was on the 4th of July 2018, so you can assume it was perhaps not long before that. And the point is at, I should say this is recorded by the divisional court at paragraph 584. The point is made at 1813 to 1814. It begins at the bottom of 1813. This is in a paragraph about points worth highlighting on the implications of Paris for UK emissions reduction targets. Subparagraph 5, in considering the implications of the political agreement reached in Paris for the UK's 2050 target, it's necessary to translate the temperature goal in the agreement to what this could mean for UK emissions. Having considered this in our 2016 report, we noted that the UK 2050 target is potentially consistent with a wide range of global temperature outcomes. The CCC recommended no change to the existing 2050 target at that time, October 2016, not because a more ambitious target was infeasible, but rather because the existing UK target was potentially consistent with more ambitious global temperature goals, including that in the Paris Agreement. Now, no one's saying that 80% was bound to be enough. I think there was a general feeling that it was very likely something more would have to be done. But this is the scientific advice on which the ANPS was designated, the scientific advice that came from the CCC. CCC were as good as their word. They said it would be interesting to see what the IPCC had to say about it when they reported. And when the IPCC did report, the CCC made a recommendation. It's time to change. We go to net zero. And that was done. But this is the position. Yes, I'm grateful to Mr. Humphreys. While we're on this document, page 1816, paragraph 25, the point is reaffirmed. The claimants assert that the existing reduction target for 2050 of at least 80% is inconsistent with the aims of Paris. This is incorrect. The evidence base has moved on. Also, the prospect of improvements in the evidence base, which it's reasonable to wait for while taking actions to retain the potential to meet a higher target. Is that enough? Yes, and so 25 to 27 we refer to, but the point reiterated there at 25. Other pre-ANPS documents, I'll take from the divisional court at 587 to 592, where they're summarized. What matters for our purposes, yes, page 462 if you want the electronic number, but paragraph 588, this is the CCC's report of January 2018. This is not aviation specific, it's about independent assessment of the UK's clean growth strategy. So it said there, the Paris Agreement is likely to require greater ambition by 2050. Next paragraph, deeper reductions will be required to meet the aims of the Paris Agreement, whether by 2050 or subsequently, and various means of achieving reductions of more than 80% are spelled out. And then in the third paragraph, echoing really what you saw from 2016 in the second half of that paragraph, the IPCC will produce a special report on the implications of the Paris Agreement's 1.5 degree ambition in 2018. At that point, the government should request further advice from the committee on the implications of the Paris Agreement for the UK's long-term emissions targets. That advice was taken by the government at the Commonwealth Heads of Government meeting in April 2018. I don't need to take you to the document, but it's recorded in the Statement of Facts and Issues at paragraph 56. On the 17th of April 2018, the government announced at that meeting that after the IPCC report later that year, it would be seeking advice from the CCC on the implications of the Paris Agreement. In the event, the IPCC report, though it was reviewed in draft by governments around the world in January and February 2018, that's recorded by the Divisional Court at 589, was published only in October 2018, that's paragraph 590. and their IPCC conclusion was that limiting warming to 1.5 as opposed to 2 would significantly reduce the risk of challenging impacts. Meeting 1.5 is possible. For global warming to be limited to 1.5, global net emissions of CO2 would need to fall by about 45% from 2010 levels by 2030, reaching zero by 2050. Well, the CCC's advice was the basis for the Secretary of State's approach. And I won't trouble you with the documents. They're all referred to in the ASFI, Statement of Facts and Issues, at 67 and following. So at 67, there is a citation from the evidence of Ms. Lowe, paragraph 458 of her witness statement, the reminder of just how many grounds there were in play in front of the divisional court. So reference is made there to the CCC's advice of October 2016. At the end of that paragraph, in establishing its carbon obligations, my team has followed this advice. She was the airport expansion team leader, and considered existing domestic obligations as the correct basis for assessing the carbon impact of the project, not appropriate at this stage for the government to consider any other possible targets that could arise through Paris. That's page 780. You want the e-bundle reference, and the next reference is Ursula Stevenson, a consultant to the government. That's at 824 of the electronic bundle. She supports what Caroline Lowe says, that the UK should not set new UK emissions targets now. The AOS has followed this advice. This is the appraisal of sustainability, and considered existing domestic legal obligations as the correct basis for assessing the carbon impact of the project. At this stage, it's not possible to consider what any future targets might be recommended by the CCC. Should more ambitious targets be recommended and set, then government will be required to make appropriate policy decisions across all sectors of the economy to limit emissions accordingly. The point being not simply that the science was still solidifying, but that policy decisions would have to be made about how the burden was to be shared within different economic sectors in the UK. Then at 69, you have the Secretary of State's pleadings, and I've already showed you that passage from their amended detailed grounds of defence. As this process was going on, this policy process, the ANPS itself was subject to consultation and to parliamentary consideration on an industrial scale. And I can take this, perhaps most conveniently, because I can take it very briefly, from the Annex 1 to the ASFI. I think the chronology, that is, I think it's 93, the electronic bundle. And that sets out the scale of it. So February 2017, there you have the first DFT consultation on the draft ANPS and AOS. 16 weeks, that was the one that had more than 70,000 responses. October, you had the further consultation. November, the Transport Committee is appointed to carry out the parliamentary scrutiny. March, the Transport Committee publishes its report, including 25 recommendations. And then moving on to June, you can see that the 5th of June is a significant day. It saw the publication of the final AOS. That's at 1627. And we'll go to that underground 3. It sees the response to consultation at 1588. And it sees the response to the Transport Committee, which we don't need and isn't in the bundle. Can I show you one more internal document? It's not in the chronology, and I don't think it's referred to in the cases either, but it's a document of that same date, the 5th of June 2020. It's a note from the Secretary of State for Transport, the decision maker, to his colleagues on the relevant cabinet subcommittee. The bundle reference is 1610. And this is the note in which the Secretary of State recommended that the ANPS be laid before Parliament for a vote. And the section on carbon is at 1620 to 1621. And you'll see an acknowledgement there in 96, the government has international and domestic obligations to limit carbon emissions. Emissions from aircraft are now predicted to be lower under all schemes in 2050, more fuel-efficient aircraft, fuller capacity, slightly higher demand for flights. Exactly how international aviation carbon emissions will be incorporated into the carbon budget framework is currently uncertain, and the point is made in footnote 45 that this policy will be driven forward during the development of the aviation strategy. The department has modelled two central case scenarios, carbon traded and carbon capped. Analysis demonstrates that all three schemes, these are the three schemes being considered for a new runway, could be delivered in line with the government's climate change obligations under both modelled scenarios. That's under both carbon capped and carbon traded. The Heathrow Northwest runway scheme is forecast to have the greatest impact given the greater increase in long-haul connectivity that it's forecast to provide, but the differences between the schemes are small. The Transport Committee and respondents such as Greenpeace queried how any expansion could be delivered without a clear government policy in place in relation to carbon. The government's position remains that action to address aviation emissions is best taken at the international level, given aviation is an inherently global industry and climate change is a global rather than a local environmental issue. Any local scheme promoter would be required to put in place a number of measures in order to limit the carbon impact of the project. So what you see here is very much what you see in the pleading, it's what you see in the witness statements, but here you have a contemporaneous document written by the decision maker just a few days before the decision was taken. Then going back to the, briefly to the chronology, at 97, there's reference on the 14th and 20th of June to correspondence between the CCC and the Secretary of State. I'll take you to that when we're looking at ground one. Then on the 25th of June, the Secretary of State made 5 key pledges to Parliament, and Parliament debated and voted on the ANPS, voting in favour by a majority of 296 with support from across the House. Then the following day, there is designation, 26th of June. The ANPS itself, I will just only 2 more documents to take you to. One is the ANPS, which is at I think around 1749. Sorry, 1720 of the electronic bundle. It's also summarized in the Statement of Facts and Issues 20 to 23, and footnote 2 to our case, I think, digs out the sections I'm going to show you. But you see here, chapter 3 is about the preferred scheme, and you see discussion of carbon emissions at 361 to 369, and 369, the government concludes that both expansion via Northwest runway as its preferred scheme can be delivered within the UK's carbon obligations, and the scheme is the right choice on economic and strategic grounds regardless of the future regime to deal with emissions from international aviation. And then there's a reference to the appraisal of sustainability. Chapter 4 deals with the assessment principles, and if you look at 441, which is at page 1760, you see the reference to climate change adaptation. The Planning Act requires the Secretary of State to have regard to the desirability of mitigating and adapting to climate change in designating an NPS, and that reference there to 10.3a. Over the page 448, the applicant, this is for development consent, should demonstrate there are no critical features of infrastructure design which may be seriously affected by more radical changes to the climate. Beyond those projected, any potentially critical features should be assessed, and any adaptation measures should be based on the latest set of UK climate projections, the most recent UK climate change risk assessment, consultation and statutory consultation bodies and other appropriate climate projection data. So the need to have regard to whatever the most up-to-date projections are at the time of any DCO application. Then Chapter 5 deals with the assessment of impacts, and there's once again a section on carbon emissions at 569. This is page 1767, 569 to 583. So the first sentence of 569 references section 5.8 of the Planning Act and the need to give reasons of how it takes account of government policy. The government has a number of international and domestic obligations. Then 571 refers to the 81% target. The carbon budgets, 573, set in line with the Committee on Climate Change's advice. And 576, pursuant to the terms of the Environmental Impact Assessment Regulations. And the court is very well aware, and particularly perhaps Lord Reid, having sat in the Aberdeen bypass case, but the SEA directive in part in ground 3 and the EIA directive are sort of siblings. The SEA directive comes in first at the ANPS stage. The environmental impact assessment would still be required at the DCO stage. And pursuant to the terms of those regulations, the applicant should undertake an assessment of the project as part of the environmental statement to include an assessment of any likely significant climate factors. And we refer to those words. My friend Mr. Wolfe makes the point that this section appears under the heading carbon emissions, but there's nothing carbon specific about the EIA regulations, and the assessment must be of any likely significant climate factors. Possible relevance there to ground 4 and non-CO2. See the same thing in the footnote to the EIA regulations, refer to the significant effects of the development on, among other factors, climate. Then there's reference to the carbon impact of the project, the government's carbon obligations, greenhouse gas impacts, and so on. And one has to ask, how different would this ANPS have looked had there been a formulaic reference to Paris? In our submission, that is all there could have been given the stage that policy development had reached based on the scientific advice of the Commission on Climate Change. The last document I want to take you to post-dates the designation. It's the Consultation for Aviation Strategy. It's at page 1824 of the bundle. It's dated December 2018, and it's called Aviation 2050. And it's really to demonstrate that the promises made were being followed through after the ANPS had been adopted. And this AS consultation, December 2018, if you go to 377 and just glance at the whole section from 377 through to 397.
Can you give a page reference, sorry?
Yes, I'm sorry, page 1825 through to 1831. And you see there a very thorough treatment. This is just the opening of the consultation that was going to lead on to the aviation strategy. We haven't seen the aviation strategy yet, but this is the opening of the conversation, the consultation. And the heading is Tackling Aviation's Impact on Climate Change. So you see, for example, on 1827, a 2050 vision for tackling emissions. 383, the government proposes to negotiate in ICAO for a long-term goal for international aviation that is consistent with the temperature goals of the Paris Agreement, ideally by ICAO's 41st Assembly in 2022. Plans to negotiate for any long-term goal to be set and reviewed in the light of aviation's full climate impact, including evidence on non-carbon effects. ICAO should consider whether the IATA goal is suitable. 385, the government recognises that international action takes time, so will also consider appropriate domestic action. It talks about the 5-yearly carbon budgets and the CCC's recommendation that instead of this rather informal arrangement of the headroom, the aviation target, international aviation should be included in the formal budget by 2050. 387, but for the time being, we'll continue using the CC advice and leaving headroom. Then it proposes to accept the CCC recommendation that emissions from UK departing flights should be at or below 2005 levels in 2050. 388 makes the point that the UK has been very effective in ICAO on helping to devise a global carbon offsetting and reduction scheme for international aviation, and it's going to continue to lead efforts in ICAO to negotiate. Then 389, reference to the ETS and what's going to happen after we leave. And then sustainable fuels and so on, 390, renewable fuels, and better understanding of available carbon abatement measures. 394, non-CO2 emissions, all that's considered too. More reference to ICAO at 396, abatement options, requirements for planning applications, and so on. So I show you that to see how policy is progressing, the sort of topics that the aviation strategy is intended to address. And my learned friends might say, well, if the government could do this in December with all these nice references to Paris and non-CO2 and so on, then why couldn't it have done it in June when it designated the national policy statement? And of course, the answer is that these are two completely different types of exercise. It's apples and oranges. The ANPS was about applying existing laws and policies to determine where the need was and how it should be satisfied. This consultation is about how policy should, in the future, be determined. So that really completes everything I wanted to say on the documents. Sorry, will you excuse me one second? Sorry, I thought it had, but there's another point on page 1730. Same document, still in the ANPS. It's paragraph 138. Relationship between the airport's NPS and the aviation policy framework. The airport's NPS sets out government policy on expanding airport capacity in the southeast of England. Other government policy on airport capacity has been set out in the aviation policy framework published in 2013. The airport's NPS does not affect government policy on wider aviation issues, which the 2013 aviation policy framework and any subsequent policy statements still apply. So again, the aviation policy framework is the precursor of the aviation strategy, the 2013 edition, and this same distinction is made between government policy on wider aviation issues and planning policy, which cannot preempt or accelerate the formulation of that wider government policy. May I turn to ground one? I hope, having done that, my lords and my lady, the exercise will be shorter as we go through the grounds, and it's maybe a hostage to fortune, but I'm not concerned about time at this stage. But may I use such time as we have before 1 o'clock to introduce this. We deal with the subject, and I can take this from our case in the first instance at paragraphs 19 to 49 of our case. And our position on this is really very simple. The policy in the ANPS does set out how it takes account of government policy relating to the mitigation of and adaptation to climate change. And you've seen that in the passages I've shown you from the ANPS referred to at footnote 2 to our case. We adopt and defend in its entirety the careful reasoning of the Divisional Court at 604 to 620, paragraph 604 to 620. And the treatment of the Court of Appeal at 222 to 233 is with respect in error for the reasons we've given in our case. So sticking with our case, the first submission we make at paragraphs 23 and following is that government policy for the purposes of section 5.8 does not include unincorporated treaties. I can take this shortly because, of course, section 5.8 has always been a plan B ground. Mr. Wolfe expressly dissociated himself from it below, although I see he's embraced it cautiously at the beginning of his case for your lordships. But Plan B, as it says at paragraph 30 of its case, does not contend that all international treaties are government policy and does not argue that the Paris temperature limit is government policy just because the government has ratified the Paris Agreement. We agree. Of course, enshrining something in a treaty doesn't stop it constituting government policy. We're not saying that. It's a suggestion, Plan B, paragraph 32, that we are. But something more is required, and we've tried to set out at 24 to 27 our arguments of statutory construction. I don't think I can improve by repeating them, and which I don't think are really engaged with by the respondents, at least not so far. And then at 28 to 33, the arguments of broader principle that though a decision maker is entitled to take account of international obligations which have not been implemented into domestic law, there is no general duty to do so. And the classic formulation of that principle is in the case of YAM, which I don't take you to. It's 3223. I hope the references appear, the bundle references appear in your copy of our case to make things easier. But in the speech of Lord Mance at 35 to 36. Or perhaps I will just take you to it. 3248. The case begins at 3223. And the judgments begin at 3248. Judgment of Lord Mance, with whom Baroness Hale, Lord Clark, Lord Sumption, Lord Reed, and Lord Toulson agreed. And you can see from the bottom of paragraph 2 that the claimant was invoking in that case obligations which he alleged were imposed on the United Kingdom at the international level under Article 34 of the ECHR, European Convention for the Protection of Human Rights. And that, of course, is not one of the articles that was incorporated into UK law by the Human Rights Act 1998. And the statement of principle, which is what we rely on, comes at 3261 C to D in the speech of Lord Mance. The starting point in this connection is that domestic and international law considerations are separate. A domestic decision maker exercising a general discretion is neither bound to have regard to this country's purely international obligations nor bound to give effect to them, but may have regard to the United Kingdom's international obligations if he or she decides this to be appropriate. Then moving on through the case, there is a reference to the lumber case again in the Supreme Court at paragraph 31(1) of our case. And the point there, as was said at paragraph 46, a decision maker must follow his published policy unless there are good reasons for not doing so. The same presumption does not apply in relation to unincorporated international law. And we take the liberty of referring to an article by Lord Sales, that's at 29, international law and domestic courts, the developing framework. Again at 33.2, precisely because under English law it is established that a treaty has no force in domestic law and is incapable of operating as a direct source of rights or obligations, ratification does not constitute a representation or undertaking operating on the plane of domestic law to perform obligations under the treaty. That was written, of course, in the context of the idea that ratification might give rise to a legitimate expectation. Here we're looking at the allied concept of whether it gives rise to an obligation. But it's not suggested by Plan B that it does without more. So I don't think there's any sense in spending longer on that, at least until my friends have addressed you. The next point is that whatever the general position about treaties being or not being government policy, and we say that they're not, the Paris Agreement is not an agreement that could possibly be said to be dictating national policy. And in our submission, a weakness of the judgment of the Court of Appeal is that it simply failed to specify the respect in which the Paris Agreement could be said to be government policy. And we set out at 35 of our case the way it characterized the relevant policy. At 216, they said it was adhering to the Paris Agreement to limit the rise in global temperature. There's a general reference at 228 to the government's commitment to the Paris Agreement. But as we say at 36, the relevant point is whether anything in the Paris Agreement constituted or could constitute relevant domestic policy. And when one looks at the Paris Agreement, we submit it's clear that it didn't and it doesn't. The Paris Agreement sets a global long-term temperature goal, not national targets. And a global aim is incapable of being government policy for the purposes of assessing the potential carbon effects of an individual development scheme. Yes, we had furnished an NDC under the aegis of the EU, pursuant to Article 4 of the Paris Agreement, but our existing carbon budgets were more ambitious than the NDC furnished on our behalf. So we go on at 37 and following to develop those points in terms that I think will be familiar to you, having seen the Paris Agreement. But at 37, we set out the basics of Article 2 and Article 4. 38, we emphasize the responsibility that is left to the signatories to determine their contributions in the light of their different national circumstances. And indeed, Friends of the Earth quite correctly acknowledge that. We cite the reference at 39.1, just as Mr. Justice Supperstone, in rejecting Plan B's application for judicial review, acknowledged it in his judgment of July 2018. And the Divisional Court, we say, was absolutely right on that. At paragraph 607, we've set out the extract at 39.3 of our case. Then yes, and of course the government was committed to the international obligations that it had taken on, but it had not as yet translated those obligations into a domestic legal or policy framework. Or in the language of Paris, Article 4.2, it had not decided on any new domestic mitigation measures it was to pursue with the aim of achieving the objective of its existing NDC or any future NDC. It already had in the Climate Change Act 2008 domestic mitigation measures. Whether more was needed was at this stage a decision for the future. And there are various government statements from 2017 and 2018, which Plan B has helpfully put together at paragraphs 37 to 45 of its case, to the effect that the government was proud of its role in securing the Paris Agreement and would work hard to ensure its implementation. But precisely how it would do so had not been decided either at the international level through ICAO or domestically. And you can see this from the documents that the Court of Appeal referred to in support of its conclusions that the Paris Agreement was policy. So turning to the judgment of the Court of Appeal at paragraph 209, this is a section on statements made on behalf of the government after its ratification of the Paris Agreement. These are statements that contributed to the Court of Appeal's conclusion that the Paris Agreement was policy, page 293. Paragraph 209, this is the government paper, the Clean Growth Strategy, first published in 2017. But what is said is, at the end, the actions and investments that will be needed will ensure the shift to clean growth will be at the forefront of policy and economic decisions made by government and businesses in the coming decades. At 211, there is the reference to the Secretary of State's summary grounds of defense in the Plan B case, on which Mr. Crossland relied. Yes, the government was fully committed to the objectives in the Paris Agreement. But as they then went on to point out, the legal obligation on the parties was to prepare, communicate, and maintain NDCs. This is not the same as a legal duty or obligation to the parties individually or collectively to achieve this aim. Then 212, we have the full quotation of Andrea Leadsom. I think I took you to this before
Yes.
in the statement of facts and issues. There's another sentence added on here. She's already said there's an important set of questions to be answered. She then refers specifically to the CCC and its report in the autumn. And then I wanted to take you, but I suspect you might prefer me to do it in an hour's time, to the correspondence between the CCC and the Secretary of State that took place shortly before the ANPS was designated. I can do that now in 2 or 3 minutes, or I can do it at 2 o'clock.
I think we can wait patiently for this until 2 o'clock, Lord Anderson. We'll adjourn now and sit again at 2. Thank you very much.
I'm grateful.